minstrel. I am Mwese Modupe Mnyim. We are looking at another important aspect of the contract of sale of goods today. We are looking at import and export sales. Let me pause and ask you if you are a member of our community. If you are not one, I ask you to kindly join our community by simply clicking on the subscribe button. You'll immediately be subscribed and become a member of our community. I also like to ask you to share this video to your friends, colleagues, share it generally on other platforms if you find it useful in the end. And you need to give us a feedback. There's something you would like to see us doing and we're not doing it, you can kindly do so by dropping a comment in the comment section. And you enjoyed it, please give us a thumb up. Thank you. We are looking at import and export sales. As you know, Nigeria is heavily connected to global trade, and generally import and export sales deals with global sales or global trade, that is trade between nations. And no nation is an island entire of itself, so every nation engages with another nation for one thing they do not have or one thing they require. Nigeria is also heavily connected to the global trade, both as an importer of machinery, finished goods and raw materials, and as Nigeria is also an exporter of commodities such as oil, agricultural produce and solid minerals. So because these transactions are cross-border, they are cross-national borders, the law governing them is also a combination of a legal regime. So you have domestic Nigerian law or domestic law in relation to your own jurisdiction. Then you have international commercial law principles as well as standard trade terms, especially INCOTERMS. So my goal in this episode is to simply guide you through the essential legal features of import and export sales, and we'll be focusing on delivery terms, documents, risk allocation, payment structures and the role of customs and regulatory agencies. So we'll look now at the nature and characteristics of import and export sales. Import and export sales are simply contracts for the sale of goods where the seller and the buyer are in different nations or different countries. So what makes these contracts unique is that they require one, international transport, they require customs clearance, they require insurance consideration, they require trade documentation, and they also require the use of international standardized trade terms such as INCOTERMS. So thus, unlike simple domestic contracts of sale that many people are familiar with, these transactions involve an interconnected chain of carriers, banks, insurers, custom officers and even freight forwarders. Now let's also consider the legal framework for import and export sales, for instance in Nigeria. So I will highlight the core legal instruments that shape these types of transactions in Nigeria. Under Nigerian domestic laws, the legal framework or the laws that regulate import and sales is the SGA, which is the Sale of Goods Act. And the Sale of Goods Act is concerned with such issues as the formation, the delivery, the risk, the property as well as the remedies. So these are the issues that the Sale of Goods Act or relevant sale of good laws cover. Another law that regulates import and sales is Customs and Excise Management Act, and this act is concerned with import and export procedures, duties as well as prohibitions. Then another law is the Central Bank of Nigeria CBN guidelines, and the CBN guidelines are concerned with the regulation on Form M, the regulations on Form NXP, letters of credit as well as relevant payment regulations. We also look at Nigerian Export Promotion Council Act, and this act is concerned with control and export documentation as well as certification. The Nigerian Promotion Council Act is concerned with export documentation as well as certification. And finally, the Standards Organization of Nigeria regulations. These regulations are concerned with pre-shipment verifications as well as standards compliance, whether the particular good in issue, the production thereof has complied with the with production standards. Then the international legal instruments include the following. A These may not always have a binding effect in Nigeria, but they have those that don't even have a binding effect in Nigeria, it have at least a persuasive effect, and they are widely used in commercial practice. So the first we are looking at is INCOTERMS, which is international commercial terms. Then we'll look at the UCP 600, which is the Uniform Customs and Practice for Documentary Credits. And finally, the United Nations Convention on Contracts for the International Sale of Goods, which is known as the CISG for short. So Nigeria is not yet a party to the CISG, but is often used as a persuasive authority and is adopted in cross-border and commercial contracts. So let's take a look at Incoterms and their importance. So Incoterms are internationally recognized sets and trade terms published by the International Chamber of Commerce, the ICC, and they regulate the obligation of the buyer and the seller. They also regulate cost allocation. They also regulate risk of loss. They regulate transportation responsibilities as well as insurance obligation. So let me highlight the most important ones that are used in Nigeria. So you look, for instance, at FOB, which is free on board. Now, under the FOB, the seller's responsibility ends once the goods are placed on board the ship at the board of shipment. Now, immediately the seller is able to get the goods placed on board the designated ship at the port of shipment, then the seller's responsibility will end. That is under the FOB, the free on board. Now, the risk passes to the buyer when goods cross the ship's rail, and the buyer arranges and pays for freight and insurance. And popular for these FOBs are popular for exports from Nigeria in relation to products like cocoa, cashew, and crude oil. Now, a key authority on this is Pyrene Company Limited versus Cindia Navigation Company Authority of Citation Supply. So FOB requires placing goods on board where seller's performance is equivalent. We'll also look at the CIF, which is the cost, insurance, and freight. Now, this is one of the most important export and import terms. The seller must, one, ship the goods, two, arrange and pay for freight to the destination port, three, procure insurance for the buyer, and finally, four, tender the shipping documents to the buyer. Now, the risk, however, passes on shipment, not arrival. So once the goods are shipped, the risk passes, and a good authority on this is Binder Brothers versus Clemens Host Company, and the citation is supplied. In this case, a CIF sale is a sale of documents, not merely goods. The third one we are looking at is EXW, FCA, CPT, CIP, DAP, and DDP. Now, an EXW, also known as X works. Under this, the buyer takes maximum responsibility. The seller only makes goods available at premises. Then under the DDP, which is the delivered duty paid, the seller bears almost all the responsibilities, including clearance and delivery to the buyer. Then we are looking at FCA, CPT, and CIP, and which is widely used in multimodal transport. Now, what are the documents in import and export sales? The documents in import and export sales. International sales are often described as documentary sales. This is usually so because documents, not goods, are central to the performance of such contract. So let me emphasize the key documents that are relevant in contracts of this nature. The first is the bill of lading. This is the most important shipping document, and it serves as a receipt for the goods in issue. It also serves as evidence of the contract of carriage, and finally it serves as a document of title, allowing the transfer of ownership from the seller to the buyer. And you see all of this on the authority of Leak Barrow versus Mason citation supply. This established negotiability of the bill of lading. Another document we are looking at is commercial invoice. The commercial invoice. Now, the commercial invoice shows description, shows quantity, shows price, and shows terms of the contract. Then the third document we are looking at is insurance certificate or insurance policy, and this is required mainly under CIF or CIP contracts. Then the fourth is certificate of origin. Now, this is used to determine the tariff treatment under trade agreements, and we'll also look at Form M for imports and Form NXP for exports. So this is required under CBN regulations for all international trades. Now, the sixth we are looking at is packing list, SUNCAP certificate, pre-shipment inspection report. Now, these are required for quality and customers compliance. So let's go now to payment modes on international sales. And I will highlight four major payment modes. The first is the open account. Now, under this, a buyer pays after receiving goods, but this is of high risk to the seller, where the buyer has to pay only after he has received the goods. And then the second is advance payment. Now, buyer pays before shipment. Now, where this is done, the risk will now shift to the buyer. The risk will shift from the seller and move to the buyer. We also look at the third one, which is documentary collections. That's the DP or the DA. Now, you see, banks handle documents but do not guarantee payment. Then another means of payment is documentary credits, that is letters of credit. This is the safest and the most commonly used method in such contracts. It's governed by the UCP 600. Now, under a letter of credit, a buyer's bank undertakes to pay the seller upon presentation of conforming documents, and again ensure security for both parties. That's why it's the most favored mode of payment. For authority, kindly see the case of Stetson versus J. Henry Schroeder Banking Corporation, or citation supplied. Now, we'll now take a look at passing of property and risk in international sales. When does property pass and when does risk pass in international sales? Why Incoterms determines risk? Property or ownership is governed by contract and applicable law, which most often than not is the Sale of Goods Act or sale of the relevant sale of good law that is applicable. So see examples, for instance, under the CIF, risk passes on shipment, but property usually passes when documents are tendered. Then under the FOB, risk passes on shipment, why property depends on the intention of the parties as to when the property in the goods is supposed to pass. Let's take a look at the customs and regulation controls. The custom and regulation controls. In Nigeria, for instance, the agencies that are involved in relation to this are: 1. Nigerian Customs Service; 2. The Standard Organization of Nigeria; 3. The National Agency for Food and Drug Administration and Control. Then you have 4. Nigerian Ports Authority. You also have the Central Bank of Nigeria, and finally the Nigerian Export Promotion Council. Now, these agencies that regulate, what do they regulate? They regulate import prohibition, quality standards, foreign exchange approvals, and custom duties and tariffs as the case applies. So compliance or failure can delay goods or even result to penalties in some instances. Now, we will look at breach, remedies, as well as dispute resolution where a breach occurs. So when a breach occurs in international sales, disputes often concern late delivery, the goods did not arrive early enough, or non-conforming documents, the documents are not conforming to the goods, or damage to goods during transit, and sometimes even failure to pay under LC. And in any of these cases, the remedies available to the party who whose who has suffered a breach could be rejection of the documents, could be damages, could be specific performance, although this is rarely used, and then arbitration under the ICC or the LCIA, and in Nigeria the Lagos Court of Arbitration. You may check up the case of the Julia. Citation is supplied. Now, in that case, strict compliance with documents was said to be a requirement under CIFCs. By way of conclusion, let me say that international sale of goods, whether it's import or it's export, is fundamentally documentary, regulated, as well as risk-sensitive area of commercial law. So, understanding INCOTERMS, documentary compliance, payment systems, and Nigerian regulatory requirements is essential for any commercial lawyer or trader operating in the global marketplace. You do well to pay attention to all of this. In terms of recommendations for further reading, you can check up the SGA, you can check up the Customs and Excise Management Act, the ICC INCOTERMS 2020, the UCP 200. You can check up such cases as Pyrin versus India, Binder Brothers versus E. Clements Host Company, Leak Barrow versus Mason, all the citations supplied earlier. So thank you very much for staying with us again on this episode. You do well to click on the subscribe button if you are not already a member of our community, and you automatically be subscribed and become a member of our community. If you have enjoyed our video, kindly give us a thumb up by way of encouragement. Share the videos as well to your platforms, and give us a general feedback in the comment section. Till next time, I am Nwisi.